On a very fundamental moral sense, the government shouldn't be using Americans' dollars to fund the killing of innocent unborn children. Just regardless of whatever legal arguments are, it's just worth kind of always bringing up this point of this is an immoral practice that we shouldn't be spending anybody's money on, especially unconsenting Americans who don't want their money to go to this sorts of thing.
Merry Christmas and welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
We are recording this on the 12th day of Christmas, so we are very aggressively continuing to wish people a Merry Christmas through February 2nd. We are back from the new year, from a quiet and restful week or so, and happy to get back to it. So you're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. Now, I know we run the gamut in the types of issues and the legal and policy fields that we cover. This week, we're going to be focused on exclusively federal issues, actually. It's an interesting list of cases that we'll be talking about. So we're going to start by covering a recent First Circuit ruling involving the defunding of Planned Parenthood in the Big Beautiful Bill. Then we'll go to the VA, it's the Department of Veteran Affairs, and a recent decision to stop nearly all abortions taking place in their clinics. And we will end with a U.S. Department of Agriculture program that is likely to be involved in either rulemaking or litigation soon regarding a program that funds rural development and currently discriminates against religion. So a couple of complicated cases here. So I'm going to try to make this first case in the First Circuit simple, but a little background is probably useful here because there are actual multiple cases going on, one that got a recent ruling against Planned Parenthood. And so we just want to try to lay this out in a way that makes sense to those who haven't been following this issue closely. So as part of the, quote, Big Beautiful Bill, although I don't think it ended up being called the Big Beautiful Bill in the end. I think when it finally passed, they had changed the name a little bit, but I don't have the official name in front of me. In any event, Planned Parenthood was effectively prevented from receiving Medicaid dollars for 1 year as part of the Big Beautiful Bill. Several states sued against that provision of the bill. There were a couple of claims going on for our purposes. The main one is that Congress exceeded its authority under the spending clause in the way that it had defunded Planned Parenthood. In this particular case, a district court granted a preliminary injunction against this prohibition, so it would have effectively enjoined the government from stopping paying Planned Parenthood government money. The First Circuit, though, recently stayed the injunction and is allowing while the suit proceeds. So for now, the Big Beautiful Bill is in fact allowed to prevent Planned Parenthood from receiving federal dollars, Medicaid dollars in this case. So effectively federal dollars that pass through the states. So the court here held that contrary to the lower ruling, Congress was not unconstitutionally ambiguous. It acted within the constraints of federal law, and that the defendants in this case and not Planned Parenthood are likely to succeed on the merits of the argument. So a little background, there are a couple lawsuits. There's a parallel lawsuit going on over the same provision, but on different legal grounds. So it's just important, I think, to distinguish that. So in the other case, Planned Parenthood had claimed that actually there were prohibited entities in this bill that said if you're a prohibited entity, and then it defined prohibited entity, then you can't receive Medicaid dollars for the next year. And the argument was that the definition of prohibited entity, which was we'll get to it in a minute, but there were several elements to that. You had to be a 501c3 that did primarily like women's health care, that you were an abortion provider, that you received over $800,000 a year from government grants. Basically, Planned Parenthood's argument is that that definition only covers Planned Parenthoods and their affiliates. And so they, in the other case, interesting creatively, claim that this was a bill of attainder that is prevented by the Constitution. Most of our listeners are legally savvy, but just in case you need a refresher from con law, right, a bill of attainder is basically a bill that punishes or goes after a particular person or entity specifically, right, rather than passing generally applicable bills. Like if I were to pass a law saying that, you know, Joseph Clement is going to be punished and prevented from doing XYZ, that's a bill of attainder. Can't do that. So that, like the case that we're about to discuss, An injunction was granted on that bill of attainder case by a district court, and then that was vacated by the First Circuit in December. In this case, though, Planned Parenthood is suing on the same law, but this time arguing that the section in question about the prohibited entities, section 71113, violated the spending clause for two reasons. So the argument goes, first, the statute does not furnish states with clear notice as to the meaning and application of the criteria for determining whether a provider qualifies as a prohibited entity. So in this, they're saying that there's some vagueness or ambiguity to what a prohibited entity is. And the other argument from Planned Parenthood and company is that the statute imposes an impermissible retroactive condition on Medicaid funding that states could not have anticipated by imposing this prohibited entity restriction after the plaintiff states' Medicaid plans had already been approved by the Centers for Medicare and Medicaid Services. So two basic arguments. One, it's vague. Second, states have already made their Medicaid plans, included Planned Parenthood, and now this is taking them by surprise after the fact and is impermissible. So district court agreed with Planned Parenthood, issued a preliminary injunction preventing enforcement of this effective defunding. The First Circuit just recently stayed the injunction. So I think to me, this is all pretty straightforward, but let's go through the argument. So the First Circuit reiterates the defendants' successful arguments as follows, and says here, on the appeal, federal defendants argue that Section 71113 does not exceed Congress's power under the spending clause because the section defines prohibited entities with sufficient clarity, operates only prospectively going forward, and is of a piece with routine adjustments to the terms on which Medicaid funding is made available to states. So I don't want to dwell on this too much because I do think it's pretty straightforward. I think the First Circuit got it right. I'll talk about why for a minute, and then I want to just finish with the big picture of what I think is going on here. So first of all, Congress controls spending, right? It's quite within Congress's power to defund initiatives that Congress doesn't believe are beneficial to society. That certainly includes abortion providers. There's no constitutional right of Planned Parenthood to receive funding, no matter how much they try to argue that in various lawsuits and under various legal theories. So to the point here, definition of prohibited entity doesn't seem particularly vague or complicated. I have the quote here. Right? It's a prohibited entity is an entity, including its affiliates, subsidiaries, successors, and clinics, that as of October 1st, one is a Section 501c3 organization, right? So it has C3 status. Two is an essential community provider as described in the federal regulations that is primarily engaged in family planning services, reproductive health, and related medical care. Three, provides abortion services other than medically necessary abortions of a certain kind. And four, receives more than $800,000 in federal and state Medicaid funding in fiscal year 2023. So I don't see what's particularly vague. I think there were some arguments about the affiliate subsidiary part and some arguments about what primarily engaged in family planning services, reproductive health means. But to me, it's pretty clear. C3 status is obvious. If you're a community provider that primarily is engaged in family planning services, reproductive health, related medical care, I don't think that's particularly vague. Provides abortion services, that's obvious. Received more than $800,000 in fiscal year 2023, obvious. So it feels like grasping at straws here to see this is an impermissibly vague definition, and we don't even know who this applies to. I think, yes, we do. And the First Circuit agreed with that. So the other argument, basically, that the defunding of these abortion providers under Section 71113 is some kind of unfair or impermissible surprise, doesn't hold up. I think there's an interesting quote. The First Circuit quotes its own precedent in a 2014 case in the First Circuit called Mayhew versus Burwell, where it says that, I'm going to read from the case there, because Congress has reserved in the Medicaid Act the power to alter or amend the Medicaid program, right, which is what it did here, states have had fair notice that Congress may make incremental changes to Medicaid, and the Medicaid program contemplates that participating states may have to amend their plan to conform to federal law, even if after they have been approved. So that was exactly Planned Parenthood's argument here, that these Medicare, Medicaid state plans have been approved already, and this is an impermissible surprise. The First Circuit says, well, no, this is part of the deal. Even after you've made plans, federal government has the ability to amend these things. And basically, this is my paraphrase, but you just have to deal with it. That is part of receiving these Medicare and Medicaid dollars. So here, the First Circuit's lifted the stay. So Congress's prohibition on funding to Planned Parenthood for the time remains intact as this case goes forward. First Circuit has said that it believes that the defendants here are likely to succeed on the merits, that this is going to hold up. So again, I think just important to keep the general principle in context. Like the legal technicalities do matter, but the overarching principle, right? Congress has the power of the purse. The people elect legislators to spend money on important policy priorities and to stop spending money on what should not be funded. Congress is clearly the branch of government that is meant to do this, right? We elect, especially the House, like it has the power of the purse. The budget is an important part of what they do. They can fund or defund pretty much whatever the people elect them to fund or defund. And the way I read these lawsuits they're creative, various technical arguments involved, but at the end of the day, I think these are attempts to use the judiciary to stop the defunding of Planned Parenthood that was clearly and legitimately passed by Congress. So that's a little overview, Joseph. I'd love to turn it over to you and hear what you have to say on this case.
Yeah, like you said, Frank, at a first glance, this looks pretty straightforward, right? Congress has the authority to determine where taxpayer dollars get spent. They also have the authority to determine where taxpayer dollars don't get spent. And while not absolute, there is a deeply rooted history in America of not spending taxpayer dollars on controversial expenses. In very early America, even in colonial times, many colonies basically had these taxes to support churches, right? The money would go to paying the salary of the pastor or something like that. And even in colonial times, some colonies allowed for exemptions from these taxes. For example, Massachusetts let their citizens obtain an exemption under some circumstances. I think they may still have had to prove that they were members of a different religion other than the established one, but still there is this concept of we're not going to use your money for stuff that we shouldn't be. So even in a time of established religion in the American colonies, there were these carve-outs. And on a very fundamental moral sense, the government shouldn't be using Americans' dollars to fund the killing of innocent unborn children. Just regardless of whatever legal arguments are, it's just worth kind of always bringing up this point of this isn't a moral practice that we shouldn't be spending anybody's money on, especially unconsenting Americans who don't want their money to go to this sorts of thing. So moving on into our second update, next we'll discuss recent activity involving the Department of Veteran Affairs, the VA, and their ban on most abortions, unfortunately not all. So the Department of Veterans Affairs operates about 1,400 medical clinics and hospitals across the country, serving about 10 million veterans. So there's this beneficiary system where a veteran can opt in to receive care at these facilities, and I think their families can receive some care as well. Now, historically, the VA was very restricted in performing abortions in their facilities. It's basically never except for in cases of like the life of the mother, which we'll talk a little bit more about those supposedly life of the mother cases. But basically, U.S. law authorizes the VA to provide certain medical care. And that law is written pretty broadly. There is some room for interpretation, but the authorization that it gives the VA is not absolute. There are actually some pretty explicit carve-outs relating to abortion that I'll just read directly from in a little bit. Well, what's going on now in kind of the history in 2022, following a letter from the DOJ, the VA promulgated a new rule that allowed abortion in more circumstances than just life of the mother cases, basically in cases of rape, incest, and they also allowed abortion counseling in their facilities kind of across the board. And this is regardless of state law. So if they had a facility in a state that banned abortion, this would kind of supersede that. And the rule itself acknowledged that because of Dobbs, it wanted to basically make sure that veterans can receive abortion still. So it expanded it to allow cases of rape, incest. It kind of reasserted the life of the mother case and then abortion counseling in those facilities. And the rule stated that, I'll read very briefly from it in 2022, that the VA is taking this action, the abortion expansion, because it is determined that providing access to abortion-related medical services is needed to protect the lives and health of veterans. And just kind of that point itself, I'm not really sure how killing unborn children and providing for that protects anybody's health, protects anybody's lives, veterans and the unborn. So just kind of putting that out there. But recently, kind of the new update is following a new letter from the DOJ. The VA is reinstituting its prior near total ban on abortion in facilities. So basically, this rule was proposed back in August of last year. The DOJ responded with a new letter saying that despite our kind of previous opinion that federal law might allow this expansion, it's clear that it's unambiguous that federal law does not provide for this abortion expansion. The new rule will now proceed. Per a VA official, it's going to take effect immediately, but the rule will still kind of go through the typical process. So before getting into the relevant law itself, I mentioned this before, it's a good opportunity to address the life of the mother cases that the law still unfortunately will permit. And the fact is, abortion is never medically necessary. This is kind of something you hear tossed out a lot, where we need to protect abortion to protect the life of mothers where their pregnancy complicates kind of an existing medical condition or something like that. And there's a lot of data and a lot of scientific evidence to back this up. And abortionists themselves have conceded this point. This man, Bernard Nathanson, he's an MD who performed over 60,000 abortions throughout his career. He stated that, quote, "We can no longer conceive of any medical condition which would legitimize abortion. And that, quote, morally acceptable legislation prescribing abortion can have no exceptions written into it, not even medical ones," end quote. This was in 1991, and we've certainly seen a lot of medical advancements since then that make this statement even more true. There are other ways other than abortion to protect a woman's health when a pregnancy contributes to a medical complication. And there are ways not only in medicine to protect women's health while banning abortion, there are legislative ways to do that. Just for one example, there was a failed bill in Wisconsin from 2023 that would make abortion in Wisconsin illegal, but also clarified that doctors don't violate that abortion ban when, and I'll read briefly from that failed bill, quote, "When doctors make all reasonable medical efforts under the circumstances to preserve both the life and the woman and the life of the unborn child. Medical treatment provided to a pregnant woman by a physician that results in accidental or unintentional injury or death to the pregnant woman's unborn child is not a violation of the section." So in medicine and in the law, you can say that abortion is illegal, but still protect a woman's health when their health is endangered and a pregnancy contributes to that endangerment. So there's the segue. Abortion is never medically necessary. You can ban abortion and still protect women's health. But back to kind of what's going on here. In this new letter, the DOJ stated that the statutory language authorizing the VA to kind of do different services that restricts their ability to perform abortions is unambiguous, and that's very true. In 1992, Congress amended the federal law that governs the VA's practices. It's called Title 38. And that amended law says that the VA can, and quote, perform general reproductive health care, but not including under this section abortions, except for such care related to a pregnancy that is complicated. And the implication there is that complicated refers to life of the mother cases that supposedly exist, as we've discussed, probably don't. So the law is very clear that this abortion expansion in 2022 in VA facilities was outside of the law that the VA is governed by. And the letter also pointed out that, again, the VA is funded by taxpayer dollars. Similarly to what we were discussing before, there's a long-standing tradition of not using taxpayer dollars for such controversial things. Abortion is among the first of them. So just wrapping it up, the law is clear that the VA does not have the legal authority to perform abortions. There's this long-standing federal practice of not using taxpayer dollars to fund these practices. And it's worth pointing out that the only time and set of circumstances that federal law permits abortions in VA facilities doesn't actually exist. So Frank, there's my thoughts. I'd love to hear what you have to add here.
No, I think that's pretty comprehensive. I just want to put a finer point on the medical ethical reality that you went after there, that the whole like abortions for the life of the mother thing is a false. It's just a false example. It's been a way to open the door. Just like honestly, the like rape and incest exception things have been a way to open the door to try to normalize abortion in the policy conversation, right? Because it's much easier for those who want to expand access to abortion and have more abortions more easily available to talk about these hard cases. Say, well, what about the woman whose like life is in danger? It's like, well, okay, ectopic pregnancies, that's not an abortion. The treatment to save a woman, that's a different kind of treatment with a double effect going on. Most of these, right, if you're treating a woman's cancer, again, that's a baby might die incidentally, but it's not an abortion. So again, this idea that like, if you don't allow these things, then women are going to die. The other one that was being paddled around during after Dobbs came down and overruled Roe was that women were going to be like unable to have the procedures they needed after miscarriages if abortion was banned in a state. That's just not true, because again, that's not an abortion. So again, like very clear language problem here, that the things that proponents of abortion are saying would happen if you ban abortion and you don't allow for abortions for the life of the mother. It's just a different thing, right? Like there are no abortions for the life of the mother. there are medical procedures that might end in the death of a child. But it's really important to get language right and make distinctions and say, no, like those are just not the same thing. Anyway, this is just more of the same in the administrative state, especially under the Biden administration, frankly. And that's not a political judgment, just what we've seen in agency after agency, and we've covered several of them here. But this real problem that administrative agencies, to the extent they should even be making major rules rather than letting Congress act, that's a different question. But insofar as they are legitimate rulemaking bodies, they have to make rules that interpret, clarify, implement what Congress has done. We've had real problems of these rulemaking agencies, quote unquote, interpreting statutes by contradicting statutes. You can't do it. So it's good to see people going after them. It's good to see these highlighted, good to see them reversed whenever possible. Because it's real bad when it's like, well, this should be Congress's job to make law. Yeah, they did. It was very clear that the VA is not really supposed to be involved in abortion. So to have a rule that says, well, what Congress meant, we're going to kind of do the opposite and use a congressional statute to justify it. It's unfortunately very common, but it's good to see these things getting attention to hopefully keep these rulemaking agencies, first of all, not doing evil things like allowing abortions in VA clinics where our taxpayer dollars are supposed to be helping veterans, not killing babies, but also making sure that our rulemaking agencies are not out of control and going beyond what the statutes allow them to do. All right, so last case, this will be kind of a shorter one. It's pretty straightforward, but I think it has a couple good lessons in it. So we're moving over from the VA to the USDA. So the Department of Agriculture has several types of grant-making programs that focus on grants to nonprofit organizations that are doing beneficial things in very rural areas. So the funds involved in the program at issue here are pretty wide-ranging. They can be used for housing projects, for certain businesses, for utility access like internet and phone access. But several USDA rules prevent religious organizations from receiving these grants that are otherwise available to nonprofits for these rural development projects. So, for example, there's one rule that prohibits funds from going to buildings that will be used for religious purposes. There's an instance that Joseph found here of CareNet, which is a pro-life network, where CareNet was denied a loan to purchase and renovate a building in Vermont because it planned to hold Bible studies in a spare room. So recent update, these restrictions on religious entities and uses have been going on for years, but recently attorneys from Alliance Defending Freedom recently got involved and asked the Department of Agriculture to repeal these regulations in light of the Supreme Court's First Amendment jurisprudence as well as the Religious Freedom Restoration Act. So the argument is straightforward, one that anyone who has probably ever listened to a Napa Legal Podcast is already familiar with. Right? U.S. law prevents the government from excluding religious individuals or religious organizations from otherwise generally available public benefits. So just want to do the drum beating on this common argument here because I think this is a good example of it, right? So the reality is precedent does take a long time to trickle down and spread out, right? Supreme Court rules on something, but the lower courts are still going to get similar cases. State governments are still going to keep doing what they've done. Rulemaking agencies are often going to keep doing what they've done. So it often can take years, as we're seeing here, for precedent to trickle down and catch up and fix practices that have maybe not caught up to what the Supreme Court has, in this case, very clearly held. Right. So again, everyone's familiar who's listening to this with the line of cases from Trinity Lutheran to Carson v. Macon. Pretty clear. The principle is that a generally available benefit cannot be offered to all comers, but denied particularly to religious persons or organizations solely due to their religious character, right? Such an exclusion is not required by the Establishment Clause because funding projects or organizations that have a religious character is not the establishment of a religion, and that therefore these exclusions are not only not an Establishment Clause requirement, but excluding only religious organizations or persons from these generally available benefits, it's clearly a violation of the Free Exercise Clause. Carson v. Macon said this pretty explicitly. And so the way I read it, there's there's really no other justifiable reason that these USDA funds could be used generally for rural projects that benefit rural areas, unless those projects have a religious character or are overseen by a religious organization. The only reason I can think of is the Establishment Clause justification that the Supreme Court has clearly and repeatedly rejected. So if the Establishment Clause doesn't require these USDA exclusions of religious organizations from these otherwise generally available grants for nonprofits to do this work, I don't see any other reason that the USDA could do these things without violating the Free Exercise Clause. So I'm hopeful that we'll see the USDA and other agencies revisit a lot of these rules, because I think the federal rules are still kind of replete with these, as are a lot of state government, state laws and state practices that exclude religion based on old, like Blaine Amendment era prejudices and 20th century understandings of the Establishment Clause. So hopefully we'll see these continue to be pointed out, revisited, and we can maybe hopefully start to see these regulations come into conformity with court precedent, and more importantly, our country's tradition of allowing religion a key place in the public square to help promote the common good, right? If we're going to fund these projects to help benefit poor and rural areas with, telecoms and utilities and building projects, there's no good reason that secular nonprofits can all take part, but any religious nonprofits cannot. That's not the American tradition. I think it's pretty clearly unconstitutional, but it's also just not a good way to run this country or to use our resources.
Yeah, Frank, you mentioned the logic and argument there, where someone might say, we can't provide any government support for any religious organization because doing so would be an Establishment Clause violation. Like you said, that's been struck down so many times at the Supreme Court, and how that likely is a free exercise violation. And just to add kind of another note to that, restricting only particular denominations from receiving these benefits likely is an Establishment Clause violation. We saw that in Catholic Charities in the most recent, in last year's Supreme Court term, where basically a Wisconsin court said, we're not going to give this Catholic charity a religious exemption because their activities aren't sufficiently religious. And the Supreme Court held that that's actually an Establishment Clause violation, because it's saying that this one particular religion, it's discriminating against them in a way that establishes other religions above them. So there is, like the free exercise problem, in some instances, there actually is an Establishment Clause violation on the other side. So just then moving into my second point there, if you want to develop an impoverished area, oftentimes the best way to do it is by investing in churches and other religious organizations and nonprofits. In many rural areas in America, the church is the community center. It's the hub of everything going on. Anecdotally, this is understandable. You can think of, a local priest or pastor who knows their members of their community very well and kind of knows what they need. People congregate around the shared belief, and a lot of times that manifests itself in the local church. And there's data to back this idea up. Obviously, it's not always true. Not every rural community exists around a church. But there are studies out there that show that churches have a really important economic and civic role in these small communities. A study published in the NIH found that religious leaders in Central Appalachia, they said they could be trusted to promote disease prevention because of their relationship with people living in the area. They were trusted. People could kind of come to them for advice. So in order to kind of promote this civic goal, they're a good person to go to and work with. Another study prepared for Duke University called, I like the title of it, The Economic Halo Effect, found that rural Methodist churches in North Carolina, on average, make economic contributions of about $735,000 per year. Not actually spending that money. Always some of it is direct spending, but through, free daycare, community service, free care for older people. They provide this huge economic boom, not only for people that are in their congregation, but for everybody in the community. So there's plenty more information out there about the economic and civic impact of local churches in rural America. But it's fair to say that if you want to develop these places that are struggling, investing in local churches will have an impact far beyond just their congregation. So besides the defunct Establishment Clause claim, we can see that empirically funding small town churches can help the broader community develop.
Yeah, no, that's a great point to end on. I really liked the example from that NIH study in Appalachia. This is something that you see all over the place, not just in rural areas, but that actually when you have healthy, thriving churches, they're one of the best vehicles for social welfare, because the pastors and the leaders are actually part of a real organic network of people who know each other. And so, another example that you hear often is, inner city like welfare programs for people who need financial support and assistance. When it's just the government cutting checks, you have no idea where the money's going. You have no idea if the people are getting better, if they're abusing the system, anything like that. Whereas when welfare funding goes through a local church, a local community, the pastor knows if the father receiving that money is, falling on hard times, having a hard time keeping a job, just got laid off, or an alcoholic or a drug addict who maybe needs some intervention beyond a check, right? So there's a general principle of subsidiarity from social welfare to rural development, like here, that local organizations that actually know their people and the people's needs are a much better vehicle for actually spending that money. Now, obviously, secular nonprofits can also be small and community-based and good vehicles, but religious organizations and churches have traditionally been really important parts of these kinds of initiatives for the common good. So again, you summarized it really well at the end. The Establishment Clause claim barring these is wrong. And so funding these kind of endeavors through religious organizations is actually really good for local communities, especially poorer communities. All right. So with that, we thank you for joining us for this first episode of the Napa Legal Podcast in 2026. If you enjoy the content we're putting out, we always appreciate it if you like the podcast, subscribe to our channel on YouTube or Spotify or wherever you are listening. But we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. And finally, if you want to support the work that we're doing, I know that from Giving Tuesday through the end of the year, you were all bombarded with email requests to give money, but now we're in the new year where you're no longer being bombarded with requests to give. So if you want to give to us in your 2026 budget, this is a perfect time to start thinking about that. You can do that at napalegalinstitute.org. Thank you for joining us. We'll talk to you next week. God bless you all.